Hello, my name is Paul Infield. I'm a family law barrister, arbitrator and mediator, and I work from 36 Family here in London. And I'm going to deal today with how English and Welsh law deals with the division of finances on divorce, dissolution, the breakup of civil partnerships, and also a bit about how we deal with claims by children or on behalf of children for maintenance and property. So firstly, how does English law deal with the division of property on divorce? Well, the courts can make a number of orders on divorce or dissolution of civil partnerships. Firstly, they can make orders for maintenance, periodical payments as we call them, both in favour of the spouse, the husband or wife, and sometimes for children. I'll come back to dealing with maintenance for children, which has a complexity to it in a little while. And they can make that both before the divorce is finalised, what we call interim maintenance or maintenance pending suit, and also for the longer term, after the divorce is finalised. It can also make orders for lump sums or a series of lump sums, that is, money being paid by one party to the other, sometimes quite substantial sums, and they can be paid over a period of time. They can also make orders for what we call property adjustment orders. And property adjustment is where the court orders a property, normally a family home or another property that the parties may own, either one of the parties or both of them, and they may adjust who owns that property. So a family home, for instance, may be transferred from the joint names of the parties to the wife or the husband, or it may be ordered that the home be sold and the net proceeds of sale divided unequally. And that's an order that the courts very often make. And more recently, the courts have been allowed to make what we call pension sharing orders. That is, transferring all or part of one party's pension to the other party so that they end up with perhaps equal pensions in retirement, either equal capital or equal income. I said that I would deal with the question of maintenance for children, and that's slightly complex because for the most part, maintenance for children is dealt with by a government department called the Child Maintenance Service, and they can order one or other party, the party with whom the child isn't living, to pay maintenance. And the courts can only deal with child maintenance in a limited set of circumstances. One is where the parties agree, in which case what they agree can last for a year at least, or more if the parties agree not to go to the Child Maintenance Service. Secondly, if the child is disabled. Thirdly, if the paying party, the non-resident, the party with whom the child isn't living, earns more than a certain amount, and that at the moment is £156,000. And orders can also be made for the education of children, school fees orders, for instance, or to support children in tertiary education, in other words, university. And finally, where the paying party is not resident in the United Kingdom. But as I say, a limited set of circumstances. So how do the courts decide what orders to make? In deciding that, the courts are required by the Act of Parliament, the statute, the Matrimonial Causes Act 1973, to take into account 8 things, some of which in practice are more important than others. So firstly, the things that the parties have, so the income, the assets, their other financial resources which they either have or are likely to have in the foreseeable future, including any earning capacity which they could have. So very often in cases, it will be said that the wife, for instance, should be going out and earning more or earning something, and that's something that very often the courts have to wrestle with. And if a party, for instance, and it sometimes happens, gives up work as a way of trying to get back at the other party in the divorce, the courts can ascribe to them an earning capacity even if they're not earning that amount. And if a person is about to receive a large sum of money, that may be taken into account. So the things that they've got or can reasonably get. Secondly, in some ways as importantly, is the needs of the parties, the needs, obligations and responsibilities. What we call for shorthand the needs of the parties. And they are particularly important, and in many cases the courts will only really be concerned with what the parties have and what their reasonable needs are. And feeding into the question of what the parties' needs are some of the other factors under Section 25 of the Matrimonial Causes Act. So things like their ages, how long the marriage was, the standard of living they enjoyed during the marriage, their health. So obviously the needs, supposedly, of a millionaire will be rather different from that of a pauper. Their health will be relevant because if one of the parties is ill, their needs will be different from someone who is healthy. Their ages are relevant because obviously the needs of someone in their 70s or 80s will be different from someone in their 20s and 30s. And then there are two factors which people often concern themselves about, but which are in practice very seldom relevant. There's the contributions which the parties made to the marriage. In practice, the courts almost always regard the contributions as equal, even if they are in different ways. Very often, traditionally, the husband going out to earn a living, the wife staying at home and looking after the home and the children. Whatever the contribution, in general terms, the courts will regard them as equal. And then there is conduct. Very often, one or other of the parties to a divorce will allege that the other party has been guilty of conduct, adultery, violence, wasting money. But in practice, the courts very seldom consider that should be taken into account, even if it's true, unless it's so serious that it would cause one or other to gasp in astonishment at how serious it was. It's got to be very serious indeed for the courts to take it into account, and in practice, it very seldom is. So those are the rules, if you like, in how the courts divide up or are required to divide up the assets and income of the parties. But what principles do they use in doing it? Well, there's very little guidance. Certainly there are no hard and fast rules. And what's happened over the years is that the courts have built up a body of case law which guides the lesser courts in how to deal with these sort of cases. So the first thing that they're concerned with is the needs of the parties. As I said, if the assets and the income are so large that they're sufficient to satisfy the needs of the parties, though, the courts can consider what we call sharing, in other words, dividing things up fairly. Very, very occasionally, and I'm only aware of 2 cases in which this has happened, they can consider compensation, but that's not something that is ever taken into account except in the most unusual of circumstances. What's most important is that there is no principle of community property in England and Wales, unlike some other countries in the world, maybe in your country. But what the courts try to do is to divide up the assets equally. That, of course, isn't always possible or fair, because firstly, the needs of the children, one party's health, the short duration of the marriage. Of course, if one party has brought in significant assets and the marriage has only lasted a very short time, it may not be fair to divide up the assets equally. And also, if the assets are non-matrimonial, as we call it, in other words, they haven't been built up during the marriage but have been inherited by one party and haven't been mingled, used by the parties jointly during the marriage. When it comes to income, the courts really only take into account the needs of the parties. So it's not a question of dividing things up equally or sharing them. But what the courts are required to do is to consider how long any orders for periodical payments for maintenance should last, and whether it would be possible fairly to terminate such orders. There used to be a time when orders for maintenance would last for people's lifetime, but since we started to be allowed to make pension sharing orders, that's very seldom made. The courts in England and Wales are now entitled to take into account prenuptial agreements, both those made in this country and in other countries. That's a fairly recent thing. What is the position, though, is that prenuptial agreements are not binding on the courts in England and Wales. They are regarded as magnetic importance, of very great importance, and will generally be followed if they're considered by the court to be fair. But the courts do retain the jurisdiction to decide whether such agreements are fair, and if not, to depart from them. And when it comes to the costs of such proceedings, the general rule is that each party pays their own costs. Now, there are some circumstances, such as where one party has behaved badly in the litigation, where the courts will make costs orders. But in general terms, for the vast majority of cases, the courts won't make orders for costs in favour of one party against the other. So I now want to turn to deal with claims that can be made by one party against the other in England and Wales, where one of the parties has obtained a divorce against the other in a country outside England and Wales. So suppose the party who's in England and Wales thinks that the divorce in the other country has not resulted in receiving proper financial relief. And that happens in many cases in countries, not just in the Middle East and the Far East, but I've known it happen in countries nearer to this one. In any event, there is no restriction on where the divorce has happened and whether the parties can make a claim here. The only restrictions are these, that one of the parties has to be domiciled in England and Wales either at the time of the application or at the time of the foreign divorce or dissolution, or either party has been habitually resident in England and Wales for 1 year before the application, 1 year before the date of the overseas divorce becomes effective, or finally, where the dwelling house, the family home, is in England and Wales, and different rules apply to that, and I'll come to that in due course. There are limits, though, on the jurisdiction. So all of the usual matrimonial finance orders, lump sum, periodical payments, property adjustment orders, and so on, which I dealt with earlier, are available to a court under the 1984 Act. But where the jurisdiction is founded on the family home being in England and Wales, the only orders that the court can make are those that relate to that home. So transfer of property, lump sum based on that property. You can be transferred to the children and so on, but it's limited to orders relating to the family home. In order to make an application under Part 3 of the 1984 Act, the party applying needs to obtain permission, what we used to call leave, to make such an application. It's reasonably easy to obtain that permission, but you have to show that the court has jurisdiction and that the foreign court has not provided either any financial relief or proper financial relief. And the court in England and Wales will regard that fairly broadly. So it's not simply a question of whether the court in England and Wales would have made the same order. The court in England and Wales will have regard to a number of factors in deciding applications for permission, but this is not the time to go into those. So I want to turn finally to claims, financial claims relating to children. And these are made under Schedule 1 of the Children Act 1989. And these can be made in the context of marriages, but are particularly made where parties haven't been married. So they can be made whether married or not married, whether the parents have been married or not married, where the Child Maintenance Service has no jurisdiction, for instance, where one parent or the child is abroad, where the gross income minus pension contributions is more than of the paying parent is more than £156,000 a year, the top-up jurisdiction which I referred to earlier, for expenses relating to disability or education. And there are restrictions on adult children making claims in relation to education or special circumstances. But again, that's something you should take advice on if you want to make such claims. But those claims can be made, as I say, either in marriage in relation to parties who've been married or those who've merely cohabited. The proceedings are very similar in lots of ways to the way in which one makes claims in relation to financial relief in marriage. So there's a form that's issued, a Form A1, and that's followed by financial disclosure with a form called Form E1. And then you have 3 hearings, normally a first appointment, what we call a first appointment, a financial dispute resolution hearing at which the parties, with the help of the court, are encouraged to try to settle the case. And if they don't manage to settle it at that stage, a final hearing. And the court can make a range of orders. It can, as I say, make orders for periodical payments, but those are unusual and, as I say, very restricted. But the more normal orders are for lump sums for the benefit of the child, but only for the benefit of the child. Settlement of property, so normally that's a house or a flat, apartment for the benefit of the child, but that's in trust. So it's only settled for the benefit of the child during their minority, whilst they're under 18, or if they're in tertiary education, maybe for the duration of that tertiary education, but not after that. So it's not, you're not going to get an order for property to be transferred or to be settled for the life of the child or the life of the parent looking after the child. There's an important difference when it comes to costs. In proceedings under Schedule 1, the losing party can be ordered to pay, well, in fact, either party, but normally the losing party can be ordered to pay the costs of the other party. So I hope that's been helpful to you. And now I hand back to my colleague Andrzej Bajarski, who will be dealing with the next part of these webinars.